matter is State versus Isaiah Curvin, 24 TR 17. There's a name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out.
This introduction immediately sets a hook. Our returning protagonist, a Kansas sovereign citizen, has managed the spectacular feat of collecting another traffic ticket while traveling to address his first set of charges. The host highlights the sheer absurdity, a dilemma over an in-person jury trial via Zoom from Texas, before dropping the news of the new conundrum. This establishes a character's defiance and the recursive nature of his legal troubles, priming the viewer for an almost comical legal downfall.
Here, I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem.
All right. This is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court.
The judge lays out the reality: a Class B non-person misdemeanor, punishable by up to 6 months in jail and a hefty fine. Crucially, because jail time is on the table, the defendant qualified for court-appointed counsel, a critical safety net. The commentary perfectly underscores the gravity of the potential sentence versus the defendant's clear, misguided path. This moment is the last, fleeting chance of reason before the sovereign citizen ideology completely takes over the defense.
Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of the action in regard of the elements of my personal jurisdiction, the venue, and the nature, cause of action until the prosecution has properly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it
11 seconds of pure cinematic gold. The judge's measured question about legal representation is met with a definitive, fatal flaw of self-belief. Represent myself. This is the peak of hubris. The commentator rightly points out that this snap decision, rejecting free, professional legal help when facing jail time, is the single most reliable predictor of the ensuing courtroom chaos. The defendant has just volunteered for a guaranteed, self-inflicted legal loss.
Up a little bit, it's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to
I heard part of what you said, so.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me with regards of the elements of our persona jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime amity law. So I can know how to defend myself, and then I can enter my plea.
All right. Have you filed a motion for discovery in this case?
I filed in I put a special appearance in affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the special appearance.
The moment of legal theater arrives. Refusing to plead, the defendant launches the classic, legally no SOV sit interrogation, jurisdiction, nature and cause of action, and the ludicrous question of whether the court operates under common law or maritime admiralty law. This is a core absurdity on full display. The commentator brilliantly counters this, explaining the landlocked reality of Kansas and the established statutory law, instantly demolishing the premise of the entire defense strategy. A document
that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 or 5, a few pages that went through, not just one.
There's a 1-page document.
There's only one. It's supposed to be more. I faxed to more over there. It was supposed to be like 4 pages.
It's 1 page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action being upon me.
The defendant persists in his demand for jurisdictional clarity, but the judge pivots to procedure, the defendant's mysterious special appearance filing. The judge's analysis is razor-sharp. He dismisses the special appearance as an invalid, uncertified, single-page document. This segment is a perfect depiction of the judiciary calmly neutralizing SOV-sit paperwork games, reminding the defendant that non-attorney legal filings hold no special power in a court of law.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
because my special appearance didn't make it. I need to resend it as well. How can I reset it so I can have a chance to resend my special appearance because it didn't make it in? I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address. They need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
This is the intellectual climax. The commentator delivers a powerful legal correction, distinguishing the Sixth Amendment's right to be informed of charges from the defendant's erroneous belief in a right to understand them. The inference is clear, if you are too stubbornly ignorant to grasp the law, that the defense deficiency, not a constitutional violation. The judge, having heard enough legal nonsense, decisively enters a plea of not guilty, steering the case back onto its predetermined track.
About 1 hour? Okay.
Ms. Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st at...
With the plea entered, the defendant pivotally demands a jury trial, a right he must properly file for. This sets the final, suspenseful date for the confrontation. The segment culminates in the announcement of the pre-trial date and the host's hyperbolic, yet perfectly appropriate, "No God please no reaction," signaling the audience's investment in the upcoming and likely disastrous main event. The host then shifts to the closing protocol.